rises. Documenting, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah. Documenting, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah.
All right, y'all. Welcome back to another video. Now, we're not going to overtalk it. We're not going to overdo it. We're going to get right into it. Y'all already know about my copyright disclaimer, and y'all already know about my QR code to my X page. So let's continue with what we're going to discuss now. This is Megan Thee Stallion versus Milagro Elizabeth Cooper. Megan filed a motion for entry of permanent injunction against cyberstalking. Let's get into the actual documents. Preliminary statement. Plaintiff Megan Pete hereby moves pursuant to Federal Procedure 65 in Section 784.0485, Florida statutes, for the entry of a permanent injunction against defendant Milagro Cooper. Defendant's retaliatory cyberstalking campaign has caused substantial emotional distress to Ms. Pete and put her in reasonable fear for her physical safety and health. A permanent injunction against cyberstalking is warranted in light of defendants' repeated attempts to interfere with the administration of justice in relation to Ms. Pete's reporting of and proceedings arising from a violent assault on Ms. Pete. Defendants' willingness to retaliate against those who engage in essential speech related to the reporting of crimes and torturous conduct, and defendants continue harassing conduct since the verdict in this case, which demonstrates that she lacks respect for the rule of law and that only injunctive relief will be effective in this context where a defendant otherwise claims to be judgment proof. An injunction is essential to protect Ms. Pete against the threat of harm posed to her safety and well-being by defendant's conduct, and would be consistent with the jury's findings of defamation per se, intentional infliction of emotional distress, which is IIED as an acronym, and promotion of an altered sexual depiction in violation of Section 836.13 Florida statutes. Y'all can refer back to docket 226. An injunction is further warranted because the conduct engaged in by defendant serves no legitimate purpose. As such, forms of cyberstalking and victim and witness retaliation are barred under state and federal criminal laws. Ms. Pete will continue to suffer irreparable harm if defendant is permitted to further stalk, bully, and harass Ms. Pete, and to further incite defendant's mob of followers, who has been primed over the last 5 years with hateful rhetoric directed at Ms. Pete. There is no legitimate purpose to defendant's speech. It is wholly unprotected and indeed encroaches on state and federal criminal statutory bars, due not only to the underlying cyberstalking conduct, but also to the obstructive and retaliatory conduct that has sought to punish Ms. Pete and anyone who supports her as a victim and witness. In support of this motion, Ms. Pete relies on the testimony of record, all admitted trial exhibits, and Ms. Pete's previously filed petition for an injunction against cyberstalking. Ms. Pete respectfully requests a narrowly permanent injunction as set forth in the attached proposed order. All right, so factual background. Defendant coordinates with convicted felon Daystar Peterson to harass Ms. Pete. Defendant's campaign of harassment and cyberstalking stems back to July 2020, when Ms. Pete was shot by Mr. Daystar Peterson, also known as Tory Lanez, with a semi-automatic weapon and sustained serious injuries to her feet. In September 2020, just 2 months after the shooting, Mr. Peterson sent the Instagram direct message to defendant asking for her phone number. And as y'all can see there go the trial exhibit J47. Defendant not only shared her phone number, but also responded, "I don't know how you're doing, You're live, right? Tonight. But if you gave me that or any exclusive, it'd change my life. Around the same time, Mr. Peterson's father, Sunstar Peterson, sent a separate Instagram direct message asking to speak to defendant off the record. Again, exhibit from the trial. We're going to start where it says defendant promised to, without a doubt, keep her lips sealed. And such marked a genesis of a carefully coordinated scheme between defendant and the Petersons over 5 years to obstruct justice. Y'all give me 1 second. All right, sorry about that. That is to attempt to falsely exonerate Mr. Peterson by retaliating against Miss Pete, smearing Miss Pete's reputation and casting doubt on her testimony as the victim of a violent crime. By enlisting defendant to carry out this illicit and retaliatory campaign, Mr. Peterson circumvented his criminal protective and gag orders that barred him from talking about his criminal case or harassing Ms. Pete. Meanwhile, defendant was compensated for her role in the concerted action to retaliate against Ms. Pete, receiving payments of at least $3,000 from the Petersons, securing exclusive interviews and securing other financial gain from defaming Ms. Pete, who was featured repeatedly on defendant's platforms. And as y'all can see, there's another trial exhibit that it's providing. We're just going to skip over those. Y'all can pause the screen and read it, but I'm going to continue on, okay? Okay. In December of 2022, Mr. Peterson was tried and convicted of 3 felony counts for shooting Ms. Pete. He now serves a 10-year prison sentence. Despite attending every day of Mr. Peterson's criminal trial, defendant continued to spread disproven theories as to Ms. Pete's injuries and continued to falsely accuse her of lying on the stand. The evidence at trial leads the jury to render a complete verdict against defendant based on her harassment of Ms. Pete. Defendant causes Ms. Pete severe emotional distress and falsely a community directed at harassment. After a 9-day jury trial before this court, the jury expressly found that defendant falsely accused Ms. Pete of the crime of perjury, a felony, by lying under oath. Due to defendant's defamatory statements, Ms. Pete testified about how people began seeing her as somebody and say she was shot for no reason just to see somebody suffer. The purpose of these false allegations was wholly retaliatory, following Ms. Pete's complaint and testimony against Mr. Peterson. Defendant has long weaponized social media to intimidate, bully, and incite violence against Ms. Pete by continually posting and streaming about Ms. Pete to her audience, which included not just her social media followers, but also expanded to followers of anyone who liked, commented on, or reposted her statements. Prior to the civil trial, the court entered an order governing pretrial publicity on June 10th of 2025, in part to prevent defendant from continuing to spread misinformation about Ms. Pete and her case against defendant. In issuing the order governing pretrial publicity, the judge Reed considered defendant's harassment of a deponent and future trial witness, Emil Holland Briggs. He testified, gave us some very important information that goes to whether the defendant knew her statements about Ms. Pete were false. She's attempting to intimidate him and say horrible things about him in her social media posts using pretty vile language, frankly, I'm sorry, that I'm not going to repeat. It's a shame he's wasting the court's time with complete lies. Never. This obstructive conduct during the instant case highlights defendant's flagrant disrespect for the justice system in the courts. This harassment and cyber stalking resulted in defendants colluding with Ms. Pete's assailant to retaliate against Ms. Pete and to perpetuate a false narrative regarding the criminal assault on Ms. Pete. This was accomplished by a defendant intentionally spreading lies and material falsehoods, and her repeatedly attempting to undermine and discredit Ms. Pete's truthful allegations of a violent and horrific assault. Okay. We're going to go right here. She had posted on social media that, well, they didn't say media, but I added it in there. She had posted on social that she was going to be stepping away for a bit from her social media and from the public's eye. And as soon as the representatives of the Just Eats takeaway deal saw that, they immediately flagged it because they were worried in what it would mean to their campaign. The message throughout the entire cyberstalking campaign was clear: to retaliate against Ms. Pete for reporting Mr. Peterson's crimes to law enforcement. Indeed, defendant's promotion of Mr. Peterson's Cap music video, in which Mr. Peterson severs a horse leg with a bloody butcher's knife, reflected her trivialization of Ms. Pete's harm. On March the 12th of 2022, X posts connecting the Cap video to Ms. Pete. Moreover, defendant's posts demonstrate her ability to stroke hate and harassment against Ms. Pete among her followers and vast audience, whom she refers to as her mob. Defendant clearly and unequivocally, on repeated occasions, threatened to and did turn this mob on Ms. Pete for no reason other than Ms. Pete had sought to ensure that her violent assailant be held accountable and be brought to justice. At trial, Ms. Pete testified about how defendant's post making light of violent scenes from the music video created a space for people to laugh and joke about threats made to her life. And then there's a trial insert there. When I saw her tweeting about the screenshots from the video, like I said, I felt confused. I don't understand how or why she thought it was funny. And I was really sad because I felt like the people that tune into her, like she's created a space for a lot of people to come speak negatively about me. I am seeing people, continue to joke about the fact that this man has clearly threatened me in his music video, the bloodied horse leg severed as a crude and threatening metaphor for what defendant and Mr. Peterson were willing to do to Miss Pete as a result of her speaking up as a victim of a violent crime. Defendant is aware of the influence she wields. She is famous because of talking about Megan Thee Stallion in the Tory Lanez case. She got famous and known for trashing me. Defendant acknowledged that she has been speaking about Miss Pete on her platforms for the past 5 years, allegedly due to new development, new documents, new tips, new this, new that caused it to be an ongoing conversation, an ongoing point of interest for the public. And then y'all can see there another quote from the trial. In operating numerous social media platforms, including YouTube, Instagram, Twitter, Kick, and Stationhead, at least 5 days a week, defendant's statements have spread far and wide. Her statements have incited further hate and threats against Ms. P. Cult-like following. And that was a quote from Emil Holland Briggs. Y'all see that? All right, let's continue. Defendant's conduct had a lasting impact on Ms. Pete's mental and emotional well-being, thereby further interfering with her livelihood. At trial, Ms. Pete testified about how years of harassment left her feeling tired of being alive. And that's a quote, y'all. Y'all see? Okay, pause your screen and read. Okay, we're going to go right here to number 2. Defendant's harassment of Ms. Pete includes lies about her mental state, family, and alcohol consumption. Defendant's harassment campaign has not been limited to statements and conduct concerning the shooting. Rather, the retaliatory harassment is broad and far-reaching. Defendant has spewed spiteful and derogatory comments about Ms. Pete, including making unfounded accusations regarding Ms. Pete's mental capacity and alcohol consumption. Okay, pause your screen. That's a quote from the case. All right, let's start right here with defendants. Defendants incessantly false and hateful speech, which enjoys no First Amendment protection, extend to Ms. Pete's family. Defendant has falsely reported to her wide audience, the mob, that Ms. Pete's parents and grandparents were criminal thieves and drug addicts. All right, pause your screen. Okay, we're going to go right here to number 3. Defendant promotes a deepfake pornographic video of Ms. Pete. Defendant's disturbing fixation on retaliating against Ms. Pete is perhaps best reflected in her willful and malicious promotion, as found by the jury, of the deepfake pornographic video, which was distributed without Miss Pete's consent and with knowledge that the video did not depict real events. And y'all can pause y'all screen. As would anyone, Miss Pete suffered extreme embarrassment, trauma, and distress upon discovering the deep fake video of defendant's promotion and amplification of it. And then that's another quote. Pause your screen. 14th November the 20th of 2025. And that's a quote, y'all. Y'all see? I feel a little like defeated because no matter what, no matter if the video was fake or not, I feel like Milagro, I think she wanted it is to be real. So I think even if I said that's not me, they had already believed what they wanted to believe, and everybody was already talking about it. So what? What was my point in trying to say anything? Number 4. Defendant stalked Miss Pete residence online. Defendant also has access to and knowledge of Miss Pete's residential address. Specifically, defendant saved at least 2 screenshots of Miss Pete's personal residence on her phone, which she admitted to at trial. Defendant's alleged reason for possessing Miss Pete's sensitive personal information. Defendant did not dispute that she searched for, took screenshots of, and shared said information with her former attorney. Ms. Pete has expressed serious concerns for her safety in light of defendant's cyberstalking history, corroborated by the testimony of Emil Holland Briggs, her former content moderator. And then y'all can see there's a quote from the trial. Defendant was paying sites to pull these people's information, I believe like their home addresses. She would go into their backgrounds and she would use that as ammo against them. When I found out she had a picture of my house in her phone, I feel like, oh my God, this is a dangerous person. I'm thinking, why do you know where I live? What are you going to do to me? Like, are you going to come to my house? It just confirmed I don't know what this stalker is going to do with my address. Indeed, at trial, Ms. Pete testified that the purpose of the lawsuit was to stop defendant from continuing to harass and bully her. You think you can team up with a man to continue to harass and bully me online just because you don't? I don't even know what's the reason, but I want her to stop. Ms. Pete's testimony underscores the harm that she has suffered on account of defendant's harassment and cyberstalking. As the trial record reflects, defendant's social media is rife with threatening commentary against Ms. Pete. Y'all see? All right, pause your screen. We're going to go to number 5. Defendant's harassment continues even after the jury found her liable on all 3 counts. Defendant has been wholly undeterred by the recent verdict in this matter. This is perhaps unsurprising, given the record evidence demonstrating defendant's lack of respect for the justice system. It has only been 2 weeks since the jury entered a verdict in Ms. Pete's favor, and this court lifted its pretrial publicity gag order. And defendant has already returned to social media to resume her campaign by posting yet more disparaging comments directed at Ms. Pete. On December the 1st, defendant went on Instagram Live, showing no remorse for her conduct and claiming, I'm going to start working on my mixtape because apparently the only place you can bully people and talk crazy and pop S word is in the studio. But anywhere else is off limits, you know. So I'm going to get on my mixtape S word and make sure I channel all my energy into my raps and put that out and let that be artistic expression. Defendant stated intent to use the First Amendment shield of artistic expression as a sword to cause further harm to Ms. Pete's, reveals that she views the jury's verdict as a minor inconvenience, not a true deterrent. Defendant also mocked Ms. Pete's emotional distress on this Instagram Live. When a social media user commented that defendant had lost the lawsuit, she responded, I heard you blocked too. Listen, all I'm ever going to do is block y'all. I don't get on the internet and cry about what y'all say. On December the 2nd, defendant posted images of herself on X with a promotional photograph of CBS News reporter Gayle King, which members of her audience would reasonably interpret it to be a reference to Ms. Pete. See Appendix C. A reasonable viewer reading defendant's December 2nd post would understand her Gayle King photograph to reference Ms. Pete's interview with Ms. King many years ago, which defendant unsuccessfully relied on at trial to suggest Ms. Pete lied about her interactions with Mr. Peterson. And as y'all can see here right at the bottom of this page 9, y'all do see a hyperlink to said so post on Instagram. All right, let's continue. So, y'all see that? All right. Defendant later went on air with CBS News Miami and demonstrated a lack of willingness to take accountability for promoting deep fake video. When asked why she promoted the video, defendant responded. I think that's a tricky question because I think there are misconceptions about what really happened. I did say go to my likes and I did speak about it. Furthermore, when asked whether she considered the harm of the deep fake video on Miss Pete's or on Miss Pete, defendant stated, did I personally think that this would cause her to feel those ways? Absolutely not. On December the 3rd, defendant took to X once more to continue to spread misinformation about Miss Pete, misleading her followers and lying about the jury's verdict. Defendant wrote that anything that had to do with mental capacity and alcoholism never even made it to the final sheet, disregarding the jury's finding that defendant was liable for IIED based on her statements attacking Ms. Pete's mental capacity and recreational alcohol use. And it reveals that the jury's verdict with respect to those statements, defendant intends to double down and continue to perpetuate defamatory falsehoods about Ms. Pete. Defendant also wrote that the 3 defamatory statements for which the jury found her liable were not statements of fact, even though the court previously determined that they were. The message of this post was clear. Defendant unequivocally denied the jury's finding and suggested to her mob of followers that prior statements about mental capacity and alcoholism were, in fact, true, and she knew full well that they were false and defamatory. Defendant was not the only one levying attacks against Ms. Pete and misrepresenting the verdict. Shortly after the court dismissed the jury, defendant's counsel issued a press release falsely claiming that defendant was found not liable for defamation. Plaintiff's counsel privately raised concerns with such misstatements on this press release and asked for a retraction. Defendant's counsel instead posted the private email exchange on social media, subjecting plaintiff's counsel to undue harassment and doxxing by defendant's followers. And as y'all can see here, there are 2 actual inserts here. Y'all see the hyperlinks to the CBS post and also the X post. The verdict plainly states, the jury found defendant liable on count 1, defamation per se. The court only entered judgment on count 2 and 3 as no bearing on the jury's ultimate determination that defendant was liable for count 1, which is defamation. As recently as December the 15th, defendant went on another blogger's live stream and made various accusations against Ms. Pete and other trial witnesses. She accused Emil Holland Briggs of committing perjury, claiming, and I have now, been portrayed in the worst way. Somebody I used to be friends with, old child, got up on the D word stand against me, lied on me in federal court. Defendant also alleged that Ms. Pete made herself out to be the Black Regina George, who in the film Mean Girls was a bully. And she attempted to shift blame to Ms. Pete manager T. Ferris. We know him as T. Ferris, but his name is Travis Ferris, stating that he should have been up there for intentionally inflicting emotional distress because he showed Ms. Pete several of defendants' harassing social media posts. Throughout the live stream, defendants downplay her defamatory statements as mere questions, undermining the defamatory and severe emotional impact of her post on Ms. Pete. This was just the latest example of the defendant's harassment against Ms. Pete. Absent an injunction, defendants' gamesmanship will not stop. Through crowdfunding efforts designed to wholly offset the jury's damages award, defendant has eschewed the consequences of her action. As her crowdfunding page shows, defendant will continue to characterize her defamatory and torturous conduct online as rooted in the right to speak, right to question, and right to know. And then as y'all can see there go legal standard. Pause your screen, y'all can read it. And as y'all can see, here go 3 hyperlinks. Okay, let's continue. Okay, that's quotes still from the case. So we're going to start right here with in federal court. In federal court, a plaintiff seeking injunctive relief must demonstrate: 1, it plaintiff has suffered an irreparable injury; 2, remedies available at law, such as monetary damages, are inadequate to compensate for that injury; and 3, considering the balance of hardships between the plaintiff and defendant, a remedy in equity is warranted; and 4, the public interest would not be dissevered by a permanent injunction. And then y'all can see that's a quote. Now let's get into argument. All factors weigh in favor of entering a permanent stalking injunction that restrains defendant from harassing and cyberstalking Ms. Pete through her persistent and egregious online activity. Defendant's relentless campaign to defame Ms. Pete and to destroy her public image and livelihood serves no legitimate purpose, but rather an illicit one: to retaliate against Ms. Pete for her cooperation with law enforcement in the prosecution of her assailant. The sole and apparent aim of this aggressive cyberstalking campaign, as the evidence at trial revealed, was to punish Ms. Pete for none other than her status as a shooting victim of someone who happened to be close friends with the defendant. Ms. Pete established the requisite elements of cyberstalking and harassment to satisfy Section 784.0485, which is Florida statutes. Section 784.0481D, Florida statutes define cyberstalk as engaging in a course of conduct to communicate or cause to be communicated directly or indirectly words, images, or language by or through the use of electronic mail or electronic communication directed at or pertaining to a specific person, causing substantial emotional distress to that person in serving no legitimate purpose. A permanent injunction against cyberstalking under Section 784.0485 requires a showing of substantial evidence of the following elements: 1, course of conduct directed at or pertaining to a specific individual; 2, use of electronic communication; 3, substantial emotional distress; and 4, no legitimate purpose. Ms. Pete proved from her Second Amendment complaint through trial all elements of cyberstalking exist here, warranting a permanent injunction. Number 1, defendant engaged in a pattern of cyberstalking direct. Section 784.0481 defines course of conduct as pattern of conduct composed of a series of acts over a period of time, however short, which evidence a continuity of purpose. And as y'all can see there, a cyberstalking pattern of conduct is completed through electronic means. A petitioner seeking an injunction against cyberstalking need only establish 2 separate acts of following harassment or cyberstalking to prove stalking occurred. At trial, Ms. Pete introduced evidence of defendant's pattern of online bullying and harassment. Defendant used electronic means to promote an artificial pornographic video of Ms. Pete. She repeatedly accused Ms. Pete of perjury on her social media accounts and coordinated with the Petersons to inflict severe emotional distress on Ms. Pete from defendant's comments on the cap video. To her exclusive access to privileged information reserved only for Mr. Peterson and his legal team. Defendant asserted via live streams that Ms. Pete was mentally incompetent and an alcoholic. Defendant impunged Ms. Pete's family online. She flouted her knowledge of Ms. Pete's sensitive contact information, such as her residential address, and risked sharing that information via her social media platforms. And even after the jury rendered a verdict against her, defendant continued to harass Miss Pete by threatening to drop a mixtape specifically intended to bully, ridiculing Miss Pete's Gayle King interview and misrepresenting the verdict against her. In sum, defendant created a space for people to laugh and joke about threats made to Miss Pete's life. Megan Pete, y'all can see that's a quote from the trial. That pattern has repeated itself from 2020 to present day. The court should not allow defendant to continue with her aggressive and obsessive pattern of harassing, bullying, and stalking Ms. Pete online, all while defendant possesses Ms. Pete residential address and fosters a community of like-minded individuals who she refers to as the mob, geared towards hatred of Ms. Pete. Defendant cyberstalking caused Ms. Pete substantial emotional distress. In determining whether harassment or cyberstalking causes substantial emotional distress, Florida courts applying a reasonable person standard rather than a subjective standard. The emotional distress required is greater than just an ordinary feeling of distress, and it must be extreme and outrageous. And that's a quote from another case. Ms. Pete satisfies that standard. The jury found defendant liable on count 2, which is IIED. The core principle of IIED is extreme and outrageous conduct that causes severe emotional distress. And that's a quote from another case. The jury specifically found that Ms. Pete suffered severe emotional distress as a result of Ms. Cooper's extreme and outrageous conduct. The jury rendered its decision after Ms. Pete painstakingly detained how the emotional distress caused by the defendant was so substantial that she wanted to end her life. There is no dispute. Defendant caused and risked further causing Ms. Pete severe emotional distress. Defendant cyberstalking has no legitimate purpose. Y'all give me 1 second. All right, sorry about that. Uncontroverted evidence at trial revealed that the purpose behind defendant's 5-year cyberstalking campaign was to retaliate against Ms. Pete for her complaint against Mr. Peterson, to bully her into future silence, to dissuade her from cooperating in the investigation and eventual prosecution, and to punish her after she did. Only communications that severe legitimate purposes, such as lawful protest or other constitutionally protected activities, are excluded from the definition of cyberstalking. A communication serves a legitimate purpose when there is a reason for the contact other than to harass the victim. And that's a quote from another case. Here, the reason for the post went beyond mere harassment, but only in so far as they were aimed at obstruction and witness tampering. Such purposes are not legitimate and highlight the need for injunction relief. The jury determined that defendant's intentional and malicious online harassment served no legitimate purpose. As the evidence successfully showed at trial, defendant published her social media posts and live streams to harass Ms. Pete, to retaliate against her, and to hijack Ms. Pete's fame. Defendant's motivation to harass Ms. Pete sprung from her longstanding personal and professional relationship with the Peterson family, which in turn led to her efforts to interfere with the Peterson's prosecution. The jury found that defendant provide disinterested and neutral commentary. Rather, she advocated for a particular client or personal interest, indeed an illegal one. She did not impartially disseminate information, but rather pervade false information, and did so with the apparent aim of obstructing justice. Defamatory speech, obstruction, and stalking are not protected under the First Amendment. Defendant has engaged in all of these forms of unprotected speech and has indicated that she has no intention of ceasing her cyberstalking campaign. There is no legitimate purpose for criminal conduct, and no legitimate purpose for speech that furthers criminal conduct. Ms. Pete is entitled to a permanent injunction pursuant to Federal Rule of Civil Procedure 65. Ms. Pete also meets the elements for a permanent injunction pursuant to Federal R.Civ. P. 65 in federal case law. And as y'all can see there, pause your screen. Y'all can read that. We're going to continue. At 3, which is SD, Florida, September 26, 2011, issuing permanent injunction requiring defendant to remove defamatory statements from the internet. As a preliminary matter, Ms. Pete had already established the requisite element of success on the merits. A jury considered Ms. Pete's evidence and found defendant liable for defamation per se, IIED, in promotion of an altered sexual depiction. And as y'all can see, that's a case law. Look, got a new word in. Okay, so that's a case law from another case. We're going to continue. Number one, Ms. Pete faces irreparable harm from defendant's ongoing conduct. First, defendant cyberstalking conduct that has yet to cease following a 2-week trial and jury verdict has and will continue to cause Ms. Pete irreparable emotional and financial harm absent any action to the court. Y'all give me 1 second. Let me burp. Ooh, okay, excuse me. Sorry about that. And that is a case law that they're quoting there. We're going to go down here. So pause your screen, read that. We're going to go right here to Ms. Pete. Past and continuing injuries were proven at trial via Ms. Pete, Mr. Kinney, Mr. Ferris, and Dr. Walker's testimony. Ms. Pete herself testified for hours about the extreme emotional impact of defendant cyberstalking. Dr. Walker emphasized that if Ms. Pete is continued to be triggered by online posts from defendant, she may never recover from the trauma of the shooting. Furthermore, Ms. Pete proved at trial that she suffered reputational harm as a result of defendant cyberstalking. She lost at least 4 major brand deals due to emotional distress suffered at the hands of defendant. Plaintiff has endured more than enough suffering to prove irreparable harm will ensure absent a permanent injunction. Defendant has already proven that money damages are an adequate remedy. There is no adequate legal remedy for defendant's continued conduct, and that's a case law. Y'all can see there. Pause your screen and read. We're going to continue. After a trial, defendant was found liable on all counts by the jury and was ordered by the court to pay damages. Despite the jury's verdict and the court's judgment on damages, defendant continues to post online content that causes irreparable harm to Ms. Pete. Monetary damages and sanctions imposed against her clearly have not deterred defendant, and they will not adequately compensate Ms. Pete for the severe emotional distress and reputational harm she has and will continue to suffer. The balance of equities and the public interest favor injunction relief for Ms. Pete. The balance of equities tips in Ms. Pete's favor. Hold on, y'all. Give me 1 second. All right, sorry about that. Defendant would not suffer any harm from a narrowly tailored permanent injunction. She was already found liable by a jury for engaging in unlawful conduct. Another case law. Ms. Pete faces significant emotional and reputational harm if defendant continues to cyberstalk and harass her. Another case law. Pause your screen. Furthermore, the public has no interest in defendant's illegal cyberstalking of Ms. Pete. Case law there. So pause your screen. We're going to continue. All right, we're almost at the end. We're on page 19 of page 23. So let's get through this. All right. An injunction against defamation is also warranted under Florida law. Florida appellate courts have recognized that injunction relief against defamation is appropriate where defamatory statements are made as part and parcel of a course of conduct deliberately carried on to further a fraudulent or other unlawful purpose, which is a case law, as y'all can see there. And that looked like a long case law, so we're going to go right here to court. The court's finding regarding the entry of judgment on the defamation count does not change Ms. Pete's entitlement of equitable relief because Ms. Pete has established actual success on the merits. The legal test for injunction relief makes clear that that the established facts matter, not the question of whether judgment was ultimately entered. The jury's verdict on the defamation count serves to establish actual success on the merits as required by law. And that's a case law, not a case law, but that's a little law right there, as y'all can see. Indeed, Florida courts permit equitable relief against defamation even prior to a factual finding on the merits. That is, prior to the finding that the speech at issue is unprotected. If temporary injunction relief is nonetheless permitted in such circumstances, permanent equitable relief is certainly warranted following a finding on the merits that the speech is unprotected. Ms. Pete's proposed injunction complies with the statute and the Constitution. Section 784.04856A Florida statutes permits the court to enter any such relief as the court deems proper, including an injunction, to restrain the respondent from committing any act of stalking. Ms. Pete proposed injunction submitted herein is narrowly tailored to protect defendants' First Amendment rights while also targeting specific statements for which a jury already found defendant liable and for which defendant has no intention of stopping absent an injunction. Florida courts have affirmed injunctions preventing stalkers from communicating about victims to third parties when such injunctions are nearly tailored. Nearly tailored. And the prohibited speech serves no legitimate purpose. And that's a quote from a case law there. So pause your screen. We're going to go down here. Defendants' First Amendment rights will not be infringed with the proposed narrowly tailored injunction. The Supreme Court has recognized that speech falling into certain categories, and as y'all can see there, obscenity, defamation, speech, integral and illegal conduct, so-called fighting words, fraud, and true events, among other categories, is unprotected and may be restricted based on its content. And that is a quote from another case law. Several of these exceptions are implicated in the case where defendant's speech has been obscene, frequently defamatory, integral and illegal cyberstalking and retaliation, and as a whole lacks serious literacy, artistic, political, or scientific value. And that's a quote from another case law. Defendant's speech was integral to her torturous and potentially criminal cyberstalking, as well as the unlawful purpose of retaliating against Ms. Pete for her cooperation in the Peterson's prosecution. Such speech is permissibly punished under the First Amendment, which has never included a freedom to disregard these traditional limitations. Identified by the Supreme Court, as y'all can see, that's a quote from another case law, and given the ongoing course of illegal conduct and speech here, the prevention of further unprotected speech will not raise any constitutional problem. And that is a quote from another case law. The continuing course, y'all can pause your screen and read that top part. That's a quote from a case law. We're going to continue. The continuing course of repetitive torturous conduct engaged in by defendants justifies an injunction here. The injunction sought by Ms. Pete seeks only to prevent Ms. Cooper from sharing that specific harmful, unprotected, and defamatory content on her social media accounts. Conclusion: for the reasons set forth above and in the attached, Ms. Pete respectfully requests the court grant her motion for a narrowly tailored permanent injunction against cyberstalking. And we are done. We are done. We're done. We're done. That was a long read. All right. What are y'all thoughts on this? There are a lot of chatter going on online. But my question to y'all is, what is y'all's thoughts? Leave your comments in the description box below. As I always say, I want to thank y'all for getting me to 1,000 subscribers. Thank y'all so much. I couldn't do it without you guys. I appreciate y'all so much. When you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. And with that being said, I will see y'all on the next video. Y'all like, share, subscribe. Tell your friends. Bring them on over. Like, share, subscribe. All right? Y'all have a good one. Peace.